Welcome to this explainer. Today we're diving into something that is absolutely crucial, a real collision between everyday labor agreements and sweeping state laws. We're looking specifically at the Highlands County Educational Support Professionals Association, or HCSPA for short. Their current collective bargaining agreement literally dictates the working lives of hundreds of educational support employees. But here's the catch. Sweeping new legislative changes are threatening to completely turn this landscape upside down. So we're going to break down exactly what's in this current contract, the massive legislative disruptor looming on the horizon, and the urgent mobilization strategy the union has put together to protect these agreements.
Now, let's start with a number, 152. According to the union's internal presentation, at the exact time of their meeting, there were exactly 152 days left on the clock until a massive snapshot date on January 6, 2027. You guys, this isn't just a random date circled on a calendar. It is a hard, unyielding legislative deadline. It's going to determine whether the union actually keeps its right to bargain for its members or if it's forced into a super challenging recertification election. The pressure is completely on and literally every single day counts.
So here's our roadmap for today. Number 1, the Highlands ESP contract. 2, guaranteed working conditions. 3, the SB 1296 disruptor. 4, the new election math. 5, the decertification reality. And finally, number 6, the union's action plan. Let's get right into it.
Section 1. The Highlands ESP contract, the status quo. Let's establish the baseline of what is currently guaranteed to these employees.
We need to understand that these aren't just, abstract ideas floating around. Take a look at this. It's the official signature page of the 2024 to 2027 HCSPSA agreement, which was ratified back in June of 2024. Those signatures right there? They transform mere proposals into a legally binding reality. Basically, for the entire duration of this agreement, the school board of Highlands County and the association are totally locked into these terms. It's proof that the working conditions, the salaries, and the protections we're about to talk about are real, signed promises that are enforceable by law.
Moving on to Section 2, guaranteed working conditions, the stakes. Let's actually look at the tangible stakes inside that signed contract.
The sheer volume of benefits secured in this document is honestly pretty staggering. For starters, employees are guaranteed Weingarten rights. Basically, that means if they ever have to go into a disciplinary meeting, they have the right to union representation. They also have due process and just cause protections, so no continuous employee can just be fired out of the blue for arbitrary reasons. On top of that, the contract legally locks in strict limits on the defined workday and the work year. It guarantees that the employer chips in for health insurance, it secures duty-free planning and actual 30-minute lunches where they don't have to work. And, this is a big one, it outlines a rigid grievance procedure that actually ends in binding arbitration. So, if the district violates the contract, an impartial third party steps in and gets the final say.
And of course, all of this translates into concrete financial terms. What we have here is the 2024-2025 hourly grid, pulled straight from Article 12 of the contract. This matrix dictates down to the penny exactly how much employees get paid based on their pay grade and their experience steps. It's all about predictability, right? An employee knows exactly how their wages are going to progress over time. It completely removes the guesswork and stops any weird, arbitrary pay discrepancies. It locks in starting wages for bus operators, sets tool allowances for mechanics, and guarantees exact hourly rates for paraprofessionals and clerks.
All right, Section 3, the SB 1296 disruptor, the legislation. Now we have to introduce the massive new law that alters this entire landscape.
The union's own presentation actually sums up the impact of this new legislation with one extremely blunt assessment. It makes it significantly harder to win elections. Taking effect on July 1, 2026, Senate Bill 1296 fundamentally rewrites the entire rulebook for how public employee unions maintain their legal status in the state. It completely changes the threshold required to actually hold on to that legally binding contract we were just looking at.
Which brings us to Section 4, the new election math, raw data. Let's compare the old rules to the harsh math of the new reality.
The whole game changes right here in the margins. Before July 1, 2026, if an election was called, there was absolutely no minimum voter turnout required. None. And to win, the union just needed 50% plus one of the people who actually bothered to show up and vote. Pretty standard, right? But after July 1, 2026, the law requires a double majority. First off, at least 50% of the entire bargaining unit has to cast a ballot. If they don't hit that turnout number, the union just automatically loses, period. Second, even if they do get that turnout, at least 50% of the entire unit, and I mean the entire unit, not just the people who voted, has to vote yes. As you can imagine, that is a massively higher bar to clear. So let's look at how that brutal new math applies specifically to the Highlands ESP based on their current snapshot data. Out of approximately 342 employees in the bargaining unit, the presentation notes they currently have 145 members. That is roughly 42%. Now, the legislation says that to avoid that incredibly risky recertification election altogether, they have to prove that 60% of the unit are dues-paying members. So to hit 60%, they need 205 employees paying dues by that January 6, 2027 snapshot date. If they fall even one person short of that 60% supermajority, boom, an election is triggered under those crazy stringent new rules we just talked about.
Section 5. The decertification reality, the consequences. So what exactly happens if the union fails to meet this new double majority?
The presentation lays out this reality very, very objectively. If they get decertified, the union doesn't just vanish into thin air. It actually survives as a registered organization. They can still go and advocate at school board meetings, and they can still offer legal representation to their members. But look at what is lost. It is huge. That legally binding contract, it becomes null and void immediately. Poof, gone. There is suddenly no legal means to negotiate with the employer. That grievance procedure with binding arbitration we talked about totally vanishes. And here's the kicker. If the union eventually wins back its rights a whole year later, they don't just pick up where they left off. They start from a completely blank page. Nothing from that old contract is guaranteed anymore.
Section 6, the union's action plan, the response. So how on earth is leadership mobilizing to combat this threat?
The source material outlines a really urgent multi-step mobilization strategy, all aimed at beating that January 6, 2027 snapshot date. Step 1 is pure, raw numbers. Reps have to physically talk to all employees to try and reach that 60% supermajority. Again, that's 205 dues-paying members. Step 2 means collecting updated membership authorization forms, or MAFs for short. They have to make absolutely sure all 3 pages of these new forms are signed. And Step 3? They have to secure current home addresses for every single employee on file with the employer. Why? Because if this thing does go to an election, it's totally conducted via mail ballot, so bad addresses mean lost votes. They're also having people sign showing of interest, or SOI cards. These require actual wet signatures to meet really strict state verification standards, and it essentially serves as a dry run to see if they can even get 50% of the unit to sign anything in the first place.
And that leaves us with an incredibly provocative question aimed directly at the employees facing this massive shift. What are you willing to give management the right to determine? Because honestly, if that contract becomes null and void, literally everything, from the hourly wage grid to your right to due process, reverts entirely back to management control. It is a really powerful summary of the stakes here, and we're definitely going to be watching closely to see how the math unfolds over the next 152 days. Thank you so much for joining me on this explainer, and as always, keep learning.